There's a moment most people have never actually prepared for, and it happens fast. You're in the middle of something ordinary, making coffee, watching something on your phone, doing nothing in particular, and there's a knock at your door. Not a text first, not a doorbell ring from someone you were already expecting. A knock, and when you look up or move toward it, something about the cadence, something about the weight of it, tells you before you've even looked that this might not be a neighbor asking about a package or a kid selling fundraiser candy for school. If understanding your rights clearly, instead of just vaguely, is something that matters to you, I'd really appreciate it if you hit subscribe before you go, because that's exactly what this channel is built around, one real, specific legal topic at a time, explained in plain language without the unnecessary complexity. It genuinely helps more than you'd think, mostly because it tells me this kind of plain language legal content is actually reaching the people who need it, which is the entire point of doing this in the first place. All right, that's the ask. Let's keep going. And when you actually look, you see someone in a uniform, maybe more than one person, standing on the other side of your door, and they're waiting. And here is the thing I want you to understand before we go a single second further into this video, because it's the single most important framing that makes everything else make sense. That moment, the one before you've said anything, the one before you've touched the door handle, the one where you're just standing there figuring out what to do. That moment is actually the most important one of the entire encounter. Not the middle of it, not the end. The very beginning, before you've done anything at all, is where the decisions that matter most are waiting to be made. And the reason most people get those decisions wrong isn't carelessness or bad judgment. It's simply that nobody ever sat them down and walked them through this specific scenario with the care it actually deserves. So that's what this video is. This is the video that sits you down, calmly, before anything is happening, and walks through exactly what that knock means legally, what you are and are not required to do, what you should say and how to say it, and how to come out of that encounter in the strongest possible position, regardless of why someone is standing at your door in the first place. Before we get into the full breakdown, if this is the kind of information you want, practical, specific, grounded in how the law actually works rather than how people assume it works, then subscribe right now, because this is exactly what this content is built around. And a quick note before we go further. This is legal education and commentary, not legal advice for your specific situation, and some of the specific details shift from state to state. So if something serious is happening in your life, talk to an attorney who knows your jurisdiction. The core principles we're covering today hold up almost everywhere, but the margins matter in the moments that matter most. Let's start with the foundational legal concept that everything in this video sits on top of. I want to be upfront about something, because I think it's important to say directly, rather than bury in a quick disclaimer. General legal education, including everything we do here, has real limits, and it's worth understanding exactly where those limits are. What we can do here is give you a strong, accurate, genuinely useful foundation, the kind of understanding that changes how you experience a real situation when it happens. What we can't do here is account for every specific variation, every local nuance, every unique detail of your particular circumstances, because that's simply not something general content is built to do, no matter how thorough it tries to be. That's exactly why the foundation matters so much, though. A strong general understanding is what tells you when a situation is straightforward enough to handle with what you already know, and when it's specific and serious enough that it's worth bringing in someone who can look at your exact circumstances directly. All right, keeping that framing in mind, let's get into it. Because you can memorize every phrase I give you today and still misapply them if you don't understand why they work. The Fourth Amendment of the United States Constitution protects against unreasonable searches and seizures, and across more than 200 years of cases, courts have consistently treated the home as the place where that protection is at its absolute peak. Not your car, which gets a reduced version of Fourth Amendment protection. Not the sidewalk in front of your house, which gets less still. Your home, the physical interior of the place you actually live, receives the strongest constitutional protection of essentially anywhere in your life, and that doesn't depend on whether you rent or own, whether it's a house or an apartment, whether you've been there for 20 years or 20 days. The protection lives in the space, not the paperwork. Understanding why courts have treated the home this way matters, because it explains why the rules that flow from it are shaped the way they are. The framers of the Constitution were not writing in the abstract when they put the Fourth Amendment in place. They had lived through a real, specific, ongoing practice of British officials entering colonists' homes under general warrants. Documents that authorized broad searches without specifying what was being looked for or where, and they found it intolerable, not as a legal technicality, but as a fundamental violation of the kind of liberty they were trying to build. That experience is literally baked into the amendment, and it's why courts today still treat the home the way they do. The wall they built exists for a reason, and it's yours to stand behind every time someone knocks at your door. Now let's talk about what actually happens when you hear that knock, starting from the very first second, because the sequence you follow matters more than most people expect, and there are small decisions in those first few moments that carry disproportionate weight. The first thing, and I mean this literally, is to take a breath and not rush. I know the instinct when there's an unexpected knock is to move toward it immediately, to get to the door quickly, to not leave someone waiting. Resist that instinct, or at least slow it down, because you're not obligated to answer on anyone else's timeline, and the few seconds it takes to actually stop, breathe, and think are yours to take. Walk over calmly. Look through a peephole or window if you have one. Gather information before you do anything else. Is it one person? Two? Are they in uniform? Is there a vehicle you can see? None of this changes the fundamental rules, but having a clear sense of what you're dealing with before you decide anything is simply good practice. The second thing is this, and I want to say it with complete clarity so there's no ambiguity in your mind about it. You are not required to open your door. Not legally, not in the vast majority of circumstances. There is no general legal obligation that says a knock at your door creates a duty to answer it, the same way there's no obligation to pick up your phone just because it rings. Officers standing on your porch, in uniform, without anything additional behind them, are in a position legally that depends entirely on your voluntary cooperation, and voluntary cooperation is something you get to decide whether or not to give. This feels deeply counterintuitive to a lot of people, because we grow up absorbing a general sense that police at the door means you have to engage, that refusing to answer is somehow suspicious or obstructive or illegal. It is none of those things. The starting legal position is exactly the opposite of what that cultural assumption suggests, and knowing that changes everything about how you approach what comes next. The third thing, and this is where we start getting into the specific language that actually matters in real time, is that you can speak through a closed door. You can communicate everything you need to communicate without opening the door at all, without stepping outside, without putting yourself in any position that changes the legal landscape of the interaction. A firm door with you on one side and officers on the other side is not a hostile or combative setup. It's you preserving exactly the protection that exists specifically for this scenario, and any officer with real experience has had this exact kind of interaction before. The door being closed is not an escalation. It's simply you operating within your rights. Now here's the first specific thing you say, the sentence that matters more than almost any other in the entire encounter, and it's a question. Do you have a warrant? 4 words. Simple, direct, not aggressive, not accusatory. Just the single most clarifying question you can ask, because the answer to it splits the entire situation into 2 completely different tracks, each with its own set of rules and its own set of appropriate responses. Everything else in this video follows from that question and its answer. So let's walk through both tracks carefully, because they lead to genuinely different places. If the answer is no, there's no warrant. They're in the area, they want to talk, there are some questions they'd like to ask, it'll only take a few minutes. Then you are in what's sometimes called a knock-and-talk situation. And knock-and-talk is, from your side of the door, entirely voluntary. That phrase, entirely voluntary, means exactly what it sounds like. You are not required to participate. You are not required to open the door, answer questions, or do anything other than exactly what you're already doing, which is standing on the other side of a closed door. And you can communicate that clearly, without hostility, in a way that closes the interaction cleanly. Something like, I appreciate you stopping by, but I don't consent to you entering my home, and I'd rather not answer questions right now. If you want to leave your information, I'll follow up if needed. That is a complete response. It's polite, it's firm, it gives the officer a clear, definitive answer. And critically, it doesn't leave any ambiguity about whether you said yes or whether you were somehow unclear. Because one of the things that comes up regularly in contested situations afterward is the question of exactly how voluntary the consent actually was, and a clear, specific recorded statement, especially if you have a doorbell camera running, removes that question entirely. Now let's talk about what happens when officers push back, because they sometimes do, and it's worth being ready for this so the pushback doesn't catch you off guard in the moment. They might say something like, "We just have a couple of quick questions, it'll take 2 minutes." They might say, "We're not here to cause any trouble, we just need to clear something up." They might say, "This would go a lot faster if you just talk to us now." None of these statements change the underlying legal situation. They are attempts to use social pressure and the human instinct toward cooperation to get what the law doesn't automatically give them, which is access to your home and answers to their questions. And you can respond to all of them with essentially the same message, warmly, calmly, without matching any elevated energy they bring to it. "I understand, and I appreciate that, but I still don't consent to entry, and I'd rather not answer questions right now." You can repeat this, in some form, as many times as necessary. You're not being rude. You're not being difficult. You are being clear, which is the most useful thing you can be in this situation. Some officers will say, or at least imply, that refusing to cooperate looks suspicious, or like you have something to hide. This one is worth spending a moment on, because it touches something real about how people feel in this moment. Exercising a constitutional right is not evidence of guilt. Courts have said this explicitly. Choosing not to talk to police is not, by itself, indicative of anything other than choosing not to talk to police, and the same is true of declining to let someone into your home without a warrant. You are allowed to want privacy. You are allowed to want to consult an attorney before answering questions. You are allowed to simply prefer not to participate in a voluntary conversation on your porch at whatever time of day or night this is happening, for no reason whatsoever beyond the fact that it's your right not to. The response to, "This makes you look like you're hiding something," is calm and simple. "I understand you might see it that way, but I'd still rather not answer questions or allow entry right now." And then you hold that position. Now let's walk through the other track, the yes answer, the warrant answer, because this is where it gets more complex and where the specific details really matter. If officers tell you they have a warrant, the first thing you do is ask to see it. You can say, "Could you hold that up to the window or slide it under the door so I can read it?" This is not a hostile request. It's a completely reasonable one, because the warrant itself, what kind it is, what it says, what it authorizes, determines exactly what happens next. And not all warrants are the same. This is one of the most important things to understand about this entire subject, because a lot of people lump warrant into a single category, when in reality there are meaningfully different types, and the difference matters enormously to what you're actually required to allow. The first type is a search warrant. A valid search warrant is a document signed by a judge based on probable cause presented to that judge by law enforcement, authorizing officers to search a specific place for specific items. A valid search warrant for your home generally gives officers the authority to enter and search, whether or not you consent to it, because a neutral judicial officer has already reviewed the underlying justification and made a legal determination that the search is warranted. If you're presented with what appears to be a valid search warrant, it's signed by a judge, it names your address specifically, it describes what's being searched for and where. The move is not to physically block officers from entering, because attempting to physically prevent the execution of a valid warrant has its own serious legal consequences that you don't want. What you do instead is say, "Clearly, I don't consent to this search, but I understand you have a warrant, and I'm not going to interfere with you executing it." Say that sentence exactly, or something very close to it, because every word in it is doing work. "I don't consent" preserves your legal position and your ability to challenge the warrant's validity later. "I understand you have a warrant" acknowledges the reality of the situation. "I'm not going to interfere" makes clear you're not physically obstructing anything, which matters for avoiding additional charges. The whole sentence together puts on the record, clearly, that you're complying with the warrant while not conceding anything about its underlying validity, and that combination keeps the maximum number of legal options open for you afterward. The second type is an arrest warrant, and this is where a distinction that matters enormously in practice gets overlooked constantly. An arrest warrant authorizes officers to arrest a specific named person. It does not, by itself and in most circumstances, authorize a full search of your entire home. If officers have an arrest warrant for someone who is believed to be inside your residence, that warrant justifies them entering to locate and arrest that specific person, and they have what's called a Chimel right to search the area immediately within that person's reach at the time of the arrest. What it does not automatically give them is the authority to open your drawers, go through your belongings, search rooms the person wasn't in, or conduct anything approaching a comprehensive search of your living space. If you're shown what turns out to be an arrest warrant rather than a search warrant, it's worth stating, calmly and clearly, "I see this as an arrest warrant. I don't consent to a search of my home beyond what this warrant specifically authorizes." You're not refusing entry, because if there's legitimate reason to believe the named individual is inside, the warrant does authorize their entry to locate that person. But you're drawing a clear line around what the warrant covers, which matters if anything beyond that line happens, because that's the line a court will look at later. Let's talk about what makes a warrant actually valid, because knowing what to look for when an officer holds one up to your window matters. A valid warrant needs to be signed by a judge, not just filled out by an officer, not approved verbally, but signed by an actual judicial officer. It needs to specify a particular location, your address specifically, not a general area or the wrong address. If it's a search warrant, it needs to describe with reasonable particularity what is being searched for and where officers are authorized to look for it. A warrant that's for a different address, that lacks a judge's signature, that's expired, or that's too vague to have any real specificity, is potentially an invalid warrant, and you can note that calmly. "This appears to be for a different address," or "I don't see a judge's signature here," not as a way to start an argument or try to litigate the matter on your own porch, but as a way to put that observation clearly on the record. You're not going to win a legal dispute about warrant validity in your doorway, and trying to do so isn't the goal. The goal is to make sure that if there's a problem with the warrant, it exists in documented form somewhere other than just your memory, so an attorney can pursue it properly in the proper setting. Now let's talk about one of the more complicated scenarios that people frequently encounter, the one where officers say they don't have a warrant but claim they don't need one because of exigent circumstances. This is a real, recognized exception to the warrant requirement, and it's worth understanding what it actually covers versus how it sometimes gets invoked. Exigent circumstances refers to emergency situations that are so urgent that going to get a warrant first isn't practical. Someone screaming for help inside the residence, evidence that's actively in the process of being destroyed right now, an immediate ongoing threat to someone's safety. These are the core examples that courts have recognized as genuinely justifying warrantless entry. They're specific, urgent, time-sensitive scenarios, not a general catch-all for whenever officers would find entry convenient. If officers claim exigent circumstances and move to enter without your consent, you apply the same physical approach as with a valid warrant. You don't physically block the entry, because that creates problems of its own that you don't want. But you do say clearly, calmly, "I don't consent to this entry." That sentence matters here, maybe even more than it does in the warrant context, because the exigent circumstances exception is actually one of the most frequently challenged areas of search and seizure law, precisely because it's susceptible to overuse and misapplication. Courts examine exigent circumstances claims carefully, and they've thrown out plenty of them. But that examination happens in a courtroom, with an attorney, weeks or months later, in a proper legal proceeding. Not on your doorstep in the moment it's happening. Your job in the moment is to say clearly that you don't consent, not to physically resist, and then let the legal system do what it's built to do with that information. Let's talk about something that trips people up physically and practically in a way that seems small, but carries real legal weight. The difference between staying inside your home and stepping outside onto your porch. If you step outside to talk, even briefly, even just to take a piece of paper, even just because it feels rude, to talk through a closed door, you've moved from the most protected zone in your life to a significantly more ambiguous one. The porch, the entryway, the area immediately outside your door, these are not your home in the same legal sense that the interior is. Courts have treated stepping outside as a meaningful distinction in a variety of contexts, and there are scenarios where having crossed that threshold has mattered in ways that were not immediately obvious in the moment. This is why, consistently, the advice to stay inside and speak through the door isn't just a technicality. It's the choice that keeps the strongest protection around you for the entire duration of the interaction. It might feel slightly awkward or formal to conduct an entire conversation through a door. Officers encounter this regularly enough that it's not unusual in any professional sense, and the small discomfort of feeling a little unusual is genuinely worth it compared to having walked outside of your strongest protection unnecessarily. Let's walk through specific scenarios and specific language, because I want you leaving this video with actual sentences ready to use, not just a general sense of the principle, because principles under pressure tend to get fuzzy in ways that specific prepared sentences don't. When officers knock and say they'd like to come in for a few minutes, I appreciate you stopping by, but I don't consent to you entering my home. If there's something specific you need to address, I'm happy to speak through the door, or you can leave your contact information and I'll follow up through an attorney. When they say they just have a couple of quick questions, I'd rather not answer questions right now. If there's something I need to address formally, I'll do that with an attorney present. When they say it'll go easier if you just cooperate now, I understand, and I'm not trying to be difficult. I just don't consent to entry, and I'd rather not answer questions without an attorney. I appreciate your patience. When they say refusing makes you look suspicious, I understand that's one way to read it, but I know I have the right to decline, and I'd still like to keep things as I've described. When they say they'll get a warrant if you don't cooperate voluntarily, that's completely fine. I still don't consent to entry without one, and I appreciate you letting me know. And then you wait. Because this outcome, them needing to go to a judge and establish probable cause before entering your home, is actually a healthy outcome, even though it doesn't feel that way standing there. A judge deciding whether entry into your home is justified is exactly how the system is supposed to work. When they present a search warrant, could you hold that up to the window so I can read it? I want to understand what it covers. Then, after reading it, if it appears valid, I don't consent to this search, but I understand you have a warrant, and I won't interfere with you executing it. I want it noted that I'm not consenting to anything beyond the specific scope of this warrant. When they present an arrest warrant, I see this as an arrest warrant, not a search warrant. I don't consent to a search of my home. I understand this authorizes you to locate the person named, but I want to be clear, I'm not consenting to anything beyond that. These aren't magic scripts that change the law or guarantee any particular outcome. What they do is three things. They put on the record exactly where you stand. They prevent the ambiguity that can be used against you later, and they keep the interaction calm and clear in a way that serves everyone, including you, better than any version of this conversation that involves shouting, confusion, or escalation. Let's talk about the thing that I think is genuinely the hardest part of this specific scenario, harder than remembering the rules, harder than knowing what to say, and that's the emotional reality of having someone in a uniform standing at your front door and telling yourself it's okay to say no. Because this scenario is different from being pulled over in your car or being stopped on the street in a way that matters psychologically. Your home is the place where you're supposed to feel safe and in control. It's probably the place where you do feel most like yourself, most relaxed, least on guard. And having that space suddenly be the location of a stressful, high-stakes interaction is genuinely jarring, in a way that makes it harder to think clearly than almost any other context. On top of that, there's the hospitality instinct, which is real and worth acknowledging directly. Saying no to someone standing on your own front porch feels different from saying no to someone in a parking lot. There's something about doors and homes and the idea of who you invite in that carries social and cultural weight, and all of that weight is working against you in exactly the moment when you need to be making a clear-eyed legal decision. The people who get this wrong most of the time don't get it wrong because they're careless or ignorant. They get it wrong because they're human, and being human means being susceptible to the social pressure of a uniform, a direct request, and the fear of seeming uncooperative or guilty by association with the very act of saying no. That's why preparation matters here more than in almost any other context we cover. Not because the rules are more complicated, but because the emotional terrain makes it harder to apply the rules you know, and the only real counter to that is having done this thinking in advance, when nothing is at stake, when there's no pressure, when you have time to actually think about why the rules exist and what they protect, so that when the knock comes, you're not improvising, you're remembering something you already worked through calmly, a long time ago, in exactly this kind of setting. Let's talk about situations that come up less frequently, but deserve real attention, because when they do come up, people are especially unprepared for them. Let's talk about what happens if officers arrive and say they're there for a welfare check. Not because they're investigating you for anything, but because someone called in a concern about your well-being. This scenario is worth its own careful treatment, because the instinct to be helpful and reassuring runs especially strong when the framing is about your own safety, rather than a potential investigation. The framework, though, is largely the same. If you're genuinely okay, you can simply say so through the door. I'm fine. Thank you for checking. I don't need anything. In the vast majority of welfare check situations, that genuinely resolves it. The check exists to confirm you're safe, not to conduct an investigation, and confirming you're safe through a closed door accomplishes exactly what the check is designed to accomplish. Where it gets more complicated is when officers push for entry anyway, citing ongoing concern. A genuine, specific, articulable reason to believe someone inside is in immediate danger can sometimes justify entry under the exigent circumstances doctrine. Someone heard screaming, a specific threat that was communicated, an observable emergency. A general, unspecified call or concern typically doesn't clear that bar. You can say clearly, "I appreciate you checking on me. I'm safe and I don't consent to entry." That statement on the record, especially if you have it on camera, is doing exactly what it needs to do in that moment, which is making clear, explicitly, that whatever happens next isn't happening with your agreement. Let's talk about what happens when Child Protective Services or a welfare agency shows up at your door, because this is one of the most emotionally complicated versions of this scenario, and it deserves specific attention. The fear that refusing to cooperate will itself be treated as evidence of something, combined with the urgency and moral weight of anything involving child welfare, creates a pressure that tends to override people's otherwise reasonable instincts about their rights. Understanding the framework here matters specifically because of how high the stakes can feel. In most states, a child welfare investigator does not have the automatic right to enter your home without your consent or a court order, though state law varies more here than in almost any other area we're discussing today, which makes knowing your specific state's approach genuinely important. What you can do, regardless of the specific rules in your state, is ask calmly, "Can you tell me what specifically prompted this visit?" And you can add, "I'd like to cooperate, and I want to understand what's being alleged before I allow anyone inside or agree to an interview. I'd also like to have an attorney involved before we go further." That framing, cooperative in tone, specific in what you're asking for, is not obstruction. It's the response of someone who understands that serious allegations deserve serious attention, including the protection of knowing exactly what's being claimed and having proper guidance before saying or agreeing to anything. If there's a court order involved, that changes the situation the same way a warrant does, and you apply the same approach. Ask to read it, understand what it covers, comply with what it actually authorizes, and state clearly that you don't consent to anything beyond its specific scope. Let's talk about process servers and civil situations, because this comes up regularly and gets lumped in with police encounters in ways that don't quite fit. If someone shows up at your door to serve civil legal papers, a lawsuit, a subpoena, divorce documents, the calculus is meaningfully different from a law enforcement encounter. Refusing to open the door in a civil service context typically doesn't protect you in the way declining police entry can, because service of process can often be completed by alternative means depending on state law, leaving documents at the door, serving another adult resident, or having a court-authorized substitute service. And timing of service can sometimes start running in ways that affect your deadlines regardless of whether you actually accepted the papers. This is a situation where the better move is usually to actually open the door, take the papers, understand what you've been served with, and then immediately contact an attorney to understand what your timeline and response obligations are. Trying to avoid service rarely works and can sometimes actively work against you. Let's talk about code enforcement, building inspectors, and municipal officials, because this is another category that operates on its own track, somewhat separate from criminal law enforcement, but still subject to constitutional protections that most people don't know apply here. A city inspector showing up about a permit issue, an alleged code violation, or something related to your property does not have automatic authority to enter your home. In most jurisdictions, an administrative search also requires either your consent or an administrative warrant, which is a distinct tool from a criminal search warrant, but still requires judicial authorization. The same fundamental question applies. Do you have a warrant? Or should I have my attorney contact your office to schedule this, is a completely reasonable response, and it doesn't matter that the badge is municipal rather than state or federal. The principle that your home requires either consent or proper judicial authorization for entry doesn't stop applying because the inspector has a clipboard rather than a gun. Let's talk about landlords and roommates, because shared living situations add a complexity that's worth understanding in advance. The general rule in landlord-tenant situations is that a landlord cannot consent to a search of a tenant's rented unit on the tenant's behalf, because the tenant, not the landlord, holds the legally relevant privacy interest in that space during the period of their tenancy. If an officer asks your landlord to let them into your apartment, and the landlord agrees, that consent typically doesn't count as yours, and any evidence obtained that way may be subject to suppression. The landlord simply doesn't have the authority to grant what isn't theirs to give. Roommates are more complicated. Someone who shares common authority over a shared space, a living room, a shared kitchen, can potentially consent to a search of those shared spaces, even if you personally object. But that authority generally doesn't extend to spaces that are clearly, specifically, exclusively yours, your locked bedroom, your private area within the shared space. If you're in a shared living situation and this scenario ever becomes real, your own explicit stated refusal matters, even if others in the home are more willing to cooperate, particularly regarding spaces that are specifically yours. And knowing that in advance, so you can say it clearly if it comes up, is genuinely more useful than learning it afterward. Let's talk about people who aren't you answering your door, because this is a scenario people genuinely don't think about until it's happening. If a family member, a roommate, a house guest, someone watching your kids, or anyone else who might reasonably be inside your home opens your door in your absence, the same fundamental rules apply, except that person may not know them, and the social pressure of a uniform doesn't disappear just because it's not your door they're standing at. Having a real, calm, in-advance conversation with the people in your household about what to do if law enforcement knocks is one of the highest value things this video can prompt you to do. Not a scary conversation, not a paranoid one, just a practical one, the same way you'd talk about what to do in a fire. Something like, if anyone ever knocks and it's a police officer, you can say through the door that I'm not available and ask if they have a warrant. You don't have to let anyone in, and you don't have to answer questions. 30 seconds of conversation, done once, that could matter enormously if the moment ever arrives when you're not the one standing there. Let's talk about recording, because this is as relevant to a front door encounter as it is to any other interaction with law enforcement, maybe more so. In most states, you're permitted to record encounters with officers at your front door, and a doorbell camera, if you have one, is already providing exactly this kind of documentation automatically without you doing anything. The value of having a recording of the exact words exchanged, the exact sequence of events, and exactly what was or wasn't shown to you cannot be overstated if the encounter becomes the subject of any kind of legal proceeding later. Whose memory of the conversation was accurate, whether consent was genuinely given, whether something was said that contradicts the official account. These are the kinds of questions that can turn entirely on whether there's documentation or not. If you don't have a doorbell camera, your phone can serve the same function. Starting to record an interaction at your own door is not legally problematic in most circumstances, and the downside risk of having done it when nothing happens is essentially zero, while the upside when something does happen is significant. Let's talk about what to do after an encounter ends, because just like with a traffic stop, what you do in the minutes immediately following matters more than most people expect, and it's a step that's easy to skip when the immediate pressure of the interaction is over and the instinct is to just process what happened. Write down or record as quickly as possible everything you can remember, what time it was, how many officers, names or badge numbers if you caught them, what was said verbatim, as best you can reconstruct it, whether a warrant was shown, what it looked like, what address and date were on it if you could see them, whether it had a visible judge's signature, what reason, if any, was given for the visit, whether you were told anything about an ongoing investigation or case. Get all of this into a note within minutes of the interaction ending while the details are still precise and fresh, because memory fades fast and the specifics fade faster than the general impressions. That document, created immediately and contemporaneously, has genuine legal value if anything about this encounter matters later. It represents the best, most accurate account of what actually happened before time and stress and the passage of events had a chance to blur the edges. Let's talk about what to do if you realize, either during an encounter or in the days that follow, that something potentially important happened. Maybe an officer entered your home, and you're not sure whether that was legally justified. Maybe something was said or signed that you didn't fully understand at the time. Maybe you gave consent without realizing you were giving consent. The time to talk to an attorney is not when you've been charged with something, though obviously at that point you absolutely should. The time to talk to an attorney is as soon as you have a sense that something in a law enforcement interaction may have been legally significant, because the window in which certain legal challenges can be made is not unlimited, and the earlier you get proper guidance, the more options you have. If you gave consent during an encounter and later realized you didn't want to, that doesn't necessarily undo what happened, but it also doesn't mean there's nothing to examine. The voluntariness of consent, the accuracy of what was communicated, whether there was any misrepresentation about what officers were authorized to do. These are things that actual legal analysis can work with, and the time to do that analysis is sooner rather than later, with someone qualified to actually help. Let's talk about what happens if the encounter is already partially underway, if you've already opened the door a few inches before remembering any of this, or if you started answering a question before catching yourself. The instinct here is often to try to explain away what you already said, to walk it back, to clarify that you didn't mean it, and that instinct is almost never the right one to follow, because attempts to retract or recharacterize statements in the middle of an ongoing interaction tend to add confusion rather than subtract it, and they can create an impression of inconsistency that creates its own problems. What you can do, at any point in an encounter that's already underway, is simply stop and change the direction from that point forward. I'd like to stop answering questions. I don't consent to anything further, and I'd like to speak with an attorney. That sentence doesn't erase what came before it, but it puts a clear line down, changes the trajectory of the interaction from that point, and preserves your ability to have a full, honest conversation with an attorney afterward about exactly what happened and what your options are. Let's talk about the layered nature of consent specifically, because this is one of the concepts that gets glossed over in most casual conversations about this topic and deserves more careful attention than it usually gets. Consent to let someone into your home is not one single decision. It's a series of decisions, made one at a time, and each one matters independently. You can consent to someone crossing your threshold without consenting to them searching your bedroom. You can answer one question without having agreed to answer all questions. You can let someone in for one specific, stated reason, without that entry being blanket authorization for anything else they might want to do once they're inside. And critically, you can withdraw consent at any point for any reason. "I'd like you to stop and leave now" is a complete, valid withdrawal of consent for someone to remain in your home, assuming they're there on consent rather than a warrant, and it means exactly what it sounds like. None of this is complicated in theory. The difficulty is that most people encounter these questions for the first time, in the moment when they're actually happening, under pressure, without preparation, and in those conditions even simple things get murky. The preparation, done now, is what prevents that. Let's spend some time on the phrases that are most likely to actually come out of your mouth under pressure, the ones worth saying out loud right now so they're familiar when you need them. And I mean literally out loud. There's actually cognitive and memory research suggesting that saying something aloud, even just once, makes it more accessible under stress than just reading it. So if you're somewhere you can do this without feeling self-conscious, I'd encourage you to actually say these out loud as we go through them. Do you have a warrant? That's the first one. Simple, direct, non-accusatory, just a question. I don't consent to you entering my home. That's the second one. You're going to want to have this one very ready, because it's the sentence that draws the line you need drawn. I don't consent to this search, but I understand you have a warrant and I won't interfere. That's the one for when there's a valid warrant and you're complying physically while preserving your legal position. I'd rather not answer questions right now. If there's something that needs to be addressed formally, I'll do that with an attorney present. That's the one for the question scenario, and it handles both the refusal and the why in one clean sentence. I'm happy to speak through the door, but I don't consent to you entering. That's the one that keeps the door closed while still being cooperative in tone. I appreciate you stopping by, and I still don't consent to entry or to answering questions. That's the version of all of this that's warmest in tone and still completely complete in substance. I'd like you to stop and leave now. I'm withdrawing my consent for you to be here. That's the withdrawal sentence. For if someone is inside on consent and you want to change that. Each of these is complete. Each of them is legally meaningful, and each of them can be delivered in a warm, calm, non-confrontational tone that doesn't escalate anything or signal hostility. Tone matters enormously in these interactions, not because it changes your rights, but because it changes the texture of how the interaction unfolds practically, and a calm interaction is almost always a better interaction than a heated one, for you, for everyone involved. Let's talk about something worth addressing directly, which is whether there's ever a reason to voluntarily cooperate beyond what you're legally required to. The answer to that is genuinely, sometimes. If officers are at your door because of something completely benign, a neighbor dispute, a noise concern, something genuinely minor and clearly unrelated to anything that could create legal jeopardy for you, then cooperating calmly and fully is probably fine, and maybe even useful if it resolves something you want resolved. The framework we've spent this entire video building isn't meant to be applied as a blanket refusal to ever engage with law enforcement, because that's neither practical nor the point. The point is that you should know what you're choosing when you choose to cooperate, rather than cooperating by default because you didn't know you had a choice. Informed cooperation and uninformed cooperation look the same from the outside, but they feel very different from the inside, and the person who chooses to cooperate knowing they could have declined is in a fundamentally different position than the person who cooperates because they didn't know there was another option. That difference is the whole point of this video, not to make you suspicious of every interaction, not to make you hostile toward law enforcement, but to make sure that the decisions you make at your own front door are genuinely yours, made with real information, under whatever circumstances happen to arise. Let's also talk about what to do if an interaction at your door escalates in a direction you didn't expect. If voices get raised, if there's pressure you didn't anticipate, if something starts happening that you didn't prepare for. The single most useful thing in an escalating situation is to keep your own voice calm, because your voice being calm does three things at once. It keeps the interaction from feeding back on itself in a way that escalates further. It makes you harder to accurately characterize as combative or uncooperative, and it keeps your own thinking clearer, because emotional escalation and clear thinking don't coexist easily.